Hi, I'm Jen Lee with Jen Lee Law, and this week's blog post is more geared towards business owners, and it's called My Loan is Secured by What? We often talk to clients with business loans or clients who bought their business from someone else. They're making monthly payments to the seller. The problem with many of these loans or purchase agreements is that no one seems to know exactly what secures the debt. For example, a recent business loan stated that the loan was secured by all of the assets of the business. Well, at the time the loan was taken out, there actually were no assets of the business. It was brand new. The agreement was vague, and also the financing company did not file any of the required filings that needed to be done to actually secure the debt. In another case, the buyer and seller agreed to a purchase price and that the debt amount of money would be paid over 4 years. A couple of years in, the buyer figures out that the new business is really losing money and probably wasn't worth what he paid for it in the first place, and he can't afford to keep up with those payments. The problem is that the purchase agreement has no details on what the assets of the business were at the time of the sale, just that the debt is secured by the assets of the business. So there are a couple of main points to take away when you're thinking about buying, selling, or financing based on assets. The first one is make sure you actually follow the law on how to secure a debt. This likely involves talking to a business attorney to follow the right formalities. Yes, it's going to cost you some in attorney's fees up front, but far less than when the deal goes south and you are now paying an attorney at an hourly rate to try to squeeze money out of the other side. And it's quite possible the other side doesn't have any money anyway at that point. The second point is avoid vague agreements. And this is in general, avoid vague agreements, but especially in buying, selling, and financing. If the agreement is secured by all assets of the business, then you should know and have a list of what those assets are. Both sides want to point to the other side when a vague agreement ends up in trouble, like in bankruptcy court. The seller saying things like, well, the buyer should know what assets were there when she bought it, and the buyer saying, I don't know exactly what was here and what I bought later, often just costs both sides a lot of time and money they don't have. Find out how things should be done correctly before there is a problem. You'll be glad that you took the time and paid the small fee up front instead of big litigation costs later. If you need a referral to a local business attorney in California, please contact us and we'll be happy to recommend several. Thank you. I'm Jen Lee with Jen Lee Law.